Imagine this. You're pulled over on a quiet American road. The officer asks a few routine questions, then looks at your phone sitting on the passenger seat. And suddenly, you hear the words that make your stomach drop. Can I see your phone? At that moment, a single question matters more than anything else. Can police legally search your phone without a warrant in the United States? The answer might surprise you, and knowing it could protect your privacy, your freedom, and your future. Before we begin, subscribe to this channel for clear, accurate explanations of U.S. law, police powers, and constitutional rights. This channel exists to help you know your rights before you need them. Today, we'll break this down calmly, clearly, and legally, using real Supreme Court rulings, real-world scenarios, and plain English. Your smartphone is not just a phone. Under U.S. law, your phone contains your private messages, your photos and videos, your location history, your emails and financial data, your social media and search history. In other words, your phone is a digital extension of your private life. That's why the U.S. Supreme Court has repeatedly recognized that cell phones deserve special constitutional protection, far more than wallets, bags, or even cars. This protection comes from one place: the Fourth Amendment of the U.S. Constitution. The Fourth Amendment says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." In simple terms, police generally need a warrant. Warrants must be based on probable cause. Searches must be reasonable. For decades, courts struggled to apply this old constitutional language to modern technology. That changed dramatically in 2014. This is the key case every American should know. Riley v. California, 2014. The U.S. Supreme Court ruled unanimously that police cannot search the digital contents of a cell phone during an arrest without a warrant. This decision changed everything. The court explained, phones contain vast amounts of personal data. Searching a phone is far more invasive than searching pockets. Old search incident to arrest rules do not automatically apply to phones. Key takeaway: even if you are lawfully arrested, police generally cannot search your phone without a warrant. Here is the general rule under U.S. law. Police need a warrant to search your phone. But, and this is very important, there are limited exceptions. Understanding those exceptions is where most people get confused. The biggest exception is consent. If you voluntarily allow police to search your phone, a warrant is no longer required. Hypothetical scenario: an officer says, "Mind if I take a quick look at your phone?" If you say yes, you may have just given up your Fourth Amendment protection. Important points: consent must be voluntary. You can say no. You can withdraw consent. Police do not have to tell you that you can refuse. Silence is not consent, but clear permission is. This is one of the most searched legal questions in America. Passcode versus biometrics courts often treat these differently. Passcodes, PINs, passwords, generally protected by the Fifth Amendment. You usually cannot be forced to reveal or type your passcode. Biometrics, fingerprint, Face ID. Courts are split. Some allow police to compel biometric unlocking. Other courts prohibit it. The law is evolving, and it can vary by jurisdiction. Best practice: you have the right to remain silent and request a lawyer. Exigent circumstances mean emergencies. Police may search without a warrant if there is immediate danger, evidence is about to be destroyed, a suspect is fleeing, a child is at risk. Example: if police reasonably believe A phone contains real-time information about a kidnapping or an imminent threat to life. They may act without waiting for a warrant, but courts scrutinize these claims very carefully. At U.S. borders and airports, rules change. Under the border search doctrine, Customs and Border Protection has broader authority. Phones may be searched without a warrant. However, courts distinguish between basic and forensic searches. Deep forensic searches increasingly require suspicion or warrants. This area of law is still developing. Yes, police may seize your phone temporarily, but seizure is different from search. They may hold the phone, secure it to prevent data destruction, but they generally must obtain a warrant before accessing its contents. If police violate your constitutional rights, the exclusionary rule may apply. That means evidence obtained illegally may be suppressed. Prosecutors may not use it in court. This can weaken or even destroy a criminal case. Prosecutors review how evidence was obtained, decide whether it's admissible, may drop evidence or charges if rights were violated. Illegal searches can lead to case dismissal, reduced charges, suppressed evidence. Judges examine whether a warrant existed, whether an exception applied, whether consent was voluntary, whether police acted reasonably. Courts take phone searches very seriously. If police ask to search your phone, stay calm, be polite. Say, "I do not consent to a search." Do not unlock your phone. Ask for a lawyer if detained. You do not need to argue law on the street. Police can search if they're suspicious. They can search after arrest automatically. If you have nothing to hide, it's fine. Truth. Rights exist precisely for moments of pressure. This isn't about hiding wrongdoing. It's about privacy constitutional limits, preventing abuse of power, protecting innocent people. Technology evolves, but rights must evolve with it. Your phone holds your life, and under U.S. law, it deserves strong protection. Knowing your rights doesn't make you difficult, it makes you informed. If this video helped you understand your rights, like this video, subscribe for more U.S. legal education, share this with someone who carries a phone, which is everyone. The Constitution protects you, but only if you know how to use it.